Good morning and welcome to the licensing panel on Friday, the 15th of September. My name is Councillor Mockford. I shall be chairing this meeting. I should also like to introduce Councillor Wood and Councillor Farron, who make up the panel. I will get round to other introductions as I get to them. Thank you. So I've got no apologies for absence. So I shall move on to agenda item 2, which is to receive declarations of interest from members in respect of any other matter on the agenda. Do I have any? That's no. Great. So now I am going to read a verbal affirmation from the panel. The procedure the licensing panel will follow in considering the application is set out in the Licensing Act 2003. Its attendant regulations and was agreed by the Licensing Committee on the 2nd of February 2005. The Licensing Panel, in accordance with Rule 14 of the Licensing Act 2003, Hearings, Regulations 2005, decide to exclude public from all or part of the hearing where the Licensing Panel considers that it is in the public interest to do so. Thank you. Moving on to item 3, I would like to agree, by general affirmation, the minutes of the previous meeting held on the 8th of August. And
my name is Nathan Mountney. I'm solicitor to the panel. As members to my left, your right, were not present at the last meeting, it is down to me, being someone who was present, to just affirm that they were the current minutes are a correct reflection. I turn to the panel to agree.
Agreed. Thank you. Moving on to application to vary the premises licence, Licensing Act 2003. I'm going to take this moment to just whiz round the table. We have John Bryant, our Senior Licensing Officer, Lucy Corrie, our Assistant Director for Communities, Nicholas Bennett, the Environment Protection Officer. Good morning.
I'm Mandy Cuss. I'm an interested party and would like Marianne Butler to speak on my behalf, please.
Thank you very much. And gentlemen, may I take your name? Sorry. Oh, sorry.
I'm Marianne Butler and I'm an interested party and I'll be speaking on behalf of myself and Mandy.
Wonderful, thank you.
Ian Bisping, Chairman of Hancross Social Club.
Trevor Stenning, licensee of Hancross Club.
Thank you very much, thank you. Okay. At this moment, I'm now going to turn to John Bryant, our Senior Licensing Officer.
Chair, thank you. Members, the matter before you this morning is an application to vary a premises licence under the Licensing Act of 2003. The report in front of you provides information so that you can determine this application. An application pursuant to section 34 of the Licensing Act has been made by Mr Trevor Stenning on behalf of Hancross Social Club to vary the premises licence at the club address at High Street, Hancross. Representations against this application have been made by a responsible authority, the Environmental Protection Team at Mid Sussex District Council, and 5 interested parties. These have been made on the ground the prevention of a public nuisance, the promotion of public safety, and the protection of children from harm. The substance of the variation application, which I will detail shortly, is to amend the name of the site, remove 2 current licence conditions, and extend the times for the performance of live music, the times for the performance of recorded music, and for the times for the sale of alcohol by retail and the opening hours. The panel is asked to determine this application in accordance with the Licensing Act 2003, the MSDC licensing policy, the Home Office guidance, which is issued under section 182 of the Licensing Act, whilst having due regard to the submissions made by the applicant and the relevant representations. Members, for those of you who aren't familiar with the premises, the Hancross Social Club operates from premises located off the High Street in Hancross, and they are the holders of a premises licence issued under licence number PWA 0361. This licence has been issued since the 5th of August 2009 And prior to this time, the club was licensed under a club premises certificate. I have set out in the report the activities that the club is currently licensed for, and you'll see that the regulated activity of performance of dance, live music and recorded music is to 2,300 hours during the week and the weekend, and on Sunday till 22:30 hours. Sell by retail of alcohol for consumption on and off the premises is on Monday to Saturday 11 a.m. to 11 p.m. and on a Sunday 12 noon till 10:30 p.m. There are some further non-standard timings which relate to Christmas and New Year's Eve. I've set out the current opening hours for the premises, which reflect the alcohol sale times, and there are a number of mandatory conditions attached to the licence which are set out in the report. The application before the panel is to change the name of the site from Handcross Social Club to Handcross Club, and was to remove 2 existing conditions and to amend the times for existing licensable activities and the opening hours. The amended timings for live and recorded music would be, for recorded music would be every day 11 a.m. till midnight. For live music, 11 a.m. to midnight, Tuesday to Thursday, and Friday and to Saturday, 7 p.m. till midnight. Timings for the performance of dance would be 11 a.m. till midnight. Amended timings for the sale of alcohol is Monday to Saturday, 11 a.m. till midnight, and Sunday, 12 till midnight. And the opening hours to be amended accordingly. The application wished to remove the following conditions. One was existing club rules to remain in force. As I pointed out to the panel, it used to be licensed under a club premises certificate, and this is a condition which is rolled over from that time. And that the premises shall be closed and cleared of customers by 23:30 hours, Monday to Saturday, and 2,300 hours on Sundays. Obviously, that condition couldn't be complied with if the hours were amended. The application also requested the removal of a condition stating customers who go outside to smoke shall not be permitted to take drinks outside. This amendment has been withdrawn by the applicant during the consultation period and isn't under consideration. The application as received is appended to the report at Appendix 1, and the current premises licence is at Appendix 2. I've provided a site plan and pictures of the premises and the premises licence plan at Appendix 3, which I will touch on at the end of the report. As stated, representations have been received from a responsible authority, the Environmental Protection Team, and 5 members of the public who are referred to as interested parties within the Act. The representations have been made in respect of all the licensing objectives. Representations were made by the police to some of the amendments to the current licence conditions during the application, and these have been resolved during the consultation period. If the panel decides to grant the licence variation, either in full or part, I would therefore request that in addition to any other conditions that the panel felt were necessary and proportionate, the amended and additional conditions agreed between the police and the applicant are attached to the varied licence as they've been agreed by these parties. Full details of these conditions are at Appendix 4. The application was advertised at site and published in the local newspaper and complied with the regulations in respect of applications. Now, in respect to the representations, the responsible authority representations, the Environmental Protection Team makes representations in respect of the licensing objective of a prevention of a public nuisance. And Mr. Bennett from the Environmental Protection Team is here to detail their representation in full and be able to answer any questions from yourselves, the applicant or other parties. I will point out they state that they have no objection in principle to varying of the hours, but they have serious concerns regarding the actual hours applied for and make the following comments. That representations from residents have been received, raising issues including loud talking, laughing and socialising as concerns, particularly if late at night, as well as possible ASB. They go on to state that they know, having dealt with numerous complaints of this type of noise, that it can be very intrusive, causing annoyance and anxiety, and is likely to disturb sleep, if at night. It is established that alcohol consumption reduces inhibition and often leads to louder voices and more boisterous social interaction. They state that nevertheless, they want to support local businesses where possible, and they can find no previous noise complaints on their databases. They understand that there has been one complaint to the licensing team regarding noise earlier on this year, where the club denied it was their customers that were responsible. Balancing the rights of neighbours to a reasonable level of peace and quiet against the social and economic benefits of licensed premises, they state is often a complex task, which the panel, I'm sure, will agree with, where both sides are rarely satisfied and often neither are. With regard to the specific changes, they set out a number of proposals which were passed to the applicants. I will leave Mr. Bennett to detail the proposals which were passed to the applicant. During the consultation period, I didn't receive any response from the applicant in respect of the proposals from the Environmental Protection Team, which in essence were to, for the licensable activities between Sunday and Thursday to remain as on the existing licence, and the times for licensable activities on a Friday, Saturday and any Sunday followed by a bank holiday for recorded music to be amended till midnight, sale of alcohol until midnight and opening until midnight. They did state that if this proposal had been accepted, they would have been in a position to withdraw their representation. The representation from the Environmental Protection Team is attached to the report in full at Appendix 5. Now I turn to the interested party representations. The panel will be aware that there are 3 of the interested parties who are not present and 2 who are present. What I will propose to do for the interested parties that are not present, I will read out to the panel in full their representations, but obviously there's not an opportunity for yourselves or the applicants to ask any questions that they may have regard to them, but the applicants may have comments that they wish to make in respect of them. The first one is from a Gail Boosted. She has made representations on the grounds of the prevention of a public nuisance. She states that my property backs onto Handcross Club, and I have concerns about the noise that may be generated by the extended hours being requested Monday to Friday and on Sunday. I feel that they should keep to normal licensing hours of 11 AM to 11 PM, certainly on Mondays through to Thursdays and on Sundays. I would be accepting of extended hours on a Friday and Saturday, but not during the week. My bedroom is to the rear of the property and I'm aware of any noise coming from the club late at night. I do not feel there is a call for such hours in the village at the moment. I do not understand how they feel the need to make such an application when the hours they are currently open are limited normally on a Friday evening, a couple of hours midday on Saturday and Sundays and Saturday night. They might be open on other nights during the week, but I don't think it's every night. Basically, my objection is on the grounds of possible excessive noise on leaving late at night. With all applicants, I did forward to them the details of the agreed conditions between the applicant and the police. Gail Boosted replied that she had no objections regarding the police conditions that are agreed, but she still objected to the extended hours between Monday and Thursday. The second interested party is Elizabeth Scott. She has made representations on the grounds of the prevention of a public nuisance. The representation states her rental property is next door to the club. She had lived at the property since April and during that time has twice had cause to complain to the club regarding noise of people outside the club making a noise, smoking, talking and drinking until 1 or 2 AM. She states that she has also been sworn at when she's asked for the people outside to be quiet. She states that with the extended hours, she feels that she would not be able to get a decent night's sleep due to the noise of people smoking, drinking outside late at night. Again, the police conditions was forwarded to Elizabeth Scott. She replied, "Thank you for your email. I'm still confused as to how the noise levels will be addressed when the licensing hours may or may not be extended. I am affected probably more than most, as I am right next door to the club. People who smoke outside stare straight into my garden area. If the wind is in the right direction, then I'm breathing in their smoke, which wafts into my space. Why they cannot smoke further away from the building, I have no idea. I've never been able to have an early night on a Friday or Saturday night, as the licensing hours as they stand mean my dogs will bark hearing people leaving. What it would be like on extended hours, I dread to think. I suppose if I want an early night, I'll have to stay somewhere else at my own expense." And in response to attendance at the panel, she replied, "Thank you for your email. Whatever the outcome may be, I have decided to move, as constant sleep disruption is not how I like to live. I hope whoever rents after myself will benefit from the complaints, and a satisfactory result will be decided for all concerned." Marianne Butler, who's present, has made representations under all four of the licensing objectives. In general, she states, and she'll be able to detail her representations to the panel fully during her opportunity to address the panel. She states that the licensed premises has residential houses very close to its perimeter walls on three sides. It's been a noisy site in the past, customers making noise inside and outside, and she states she's complained to the council about this several times in the last few years. She refers to incidents on the 31st of April when there was excessive noise at 1 a.m. and 2 a.m, which involved foul language directed at a resident when they were asked to keep the noise down. She's concerned that they are seeking to vary their licence to sell alcohol and have live and recorded music until midnight every night, apart from midnight on a Sunday, which she states will create noise in a quiet neighbourhood. The representation then addresses the application in relation to the four licensing objectives, and it states that the detail in the measures outlined to promote the objectives within the application are confusing and do not address how they will be promoted. It draws the panel's attention to the MSDC licensing policy in respect to granting permission for the use of outside areas beyond 2300 hours, and makes comment that there's no exceptional circumstances outlined in the application. I don't believe, but the applicant will be able to clarify that the application is actually to use the outside area after 11 o'clock. There's comments in respect of the prevention of public nuisance, where the increase in times for live and recorded music until midnight, when the ambient noise levels in the neighbourhood are very low, has a real potential to cause public nuisance. This is especially highlighted as the applicants have not addressed how they intend to prevent the public nuisance, let alone preventing noise escape from the site. The representation concludes with the following, that this application seeks to allow the premises, subject of a number of complaints about it and its customers' behaviour, an extra 90 minutes, 60 minutes on Sundays, for the sale of alcohol, provision of entertainment by live and recorded music, and it states that the application is purely drafted confusing and doesn't offer any detail to indicate how the licence holders will promote the licensing objectives. And it asks that, that you do not allow them to extend the opening hours and ensure that they comply with their current licensing conditions, as they clearly have not been doing so to date. Marianne Butler's representations are attached in full for the panel at Appendix 8. And as I say, she will be able to expand on the summary that I have given. Michael and Sarah Atkinson have made representations on the ground of prevention of public order and the prevention of a public nuisance. They state that the club is at the bottom of their garden, and over the past few years the club has been well run and hasn't caused them any nuisance or cause to complain. They are concerned about the extension of the licence to allow activities into the early morning, and in particular they state, as mentioned above, the club has been well run over the last few years and is a good village community amenity, whereas a few years ago, when presumably it had a late licence, there were numerous problems with noise at late hours, and often the police had to attend because of public disorder when people exiting the premises. It would be a great shame to see the club transformed from a valuable village local asset to a late night drinking venue, stroke late night music venue, probably attracting customers from a greater catchment area. We consider that we are close enough to the club to be severely disturbed if the licence is changed and therefore wish to lodge an objection. But we do wish to be able to continue to support the club in its current format, which we consider to be appropriate for its present setting in the middle of a number of private houses. And their representations are attached to Appendix 9. The final interested party representation is from Mandy Cuss, who is present and has asked Marianne Butler to speak on her behalf. In summary, she has made representations under all 4 of the licensing objectives. She states that with regard to the application for variation of licensing of Hancross Social Club, please know I object on all fronts. She states that she has a family of 5 with 3 teenagers and they have lived right next door to the premises for 9 years. She states there have been many occasions over the years in which they've been disturbed throughout the evenings and well into the wee hours of the morning with loud people fighting, drunken behaviour and cars revving. She comments that Hancross is a small village. Her husband was born there and they moved there with their children to provide a safe and wholesome environment in which to grow up. Their neighbourhood houses 16 children under the age of 18, listening to drunk people fight and carry on while smoking and partying outside their bedroom windows late at night all week goes against this and is incredibly disruptive to the resting and sleeping patterns of children and adults alike. Why does the small village need a social club 7 days a week into the late hours for drinking, essentially a bar-type environment? It's essentially an application for a nightclub in a small, quiet village. We value the contributions the club can add to a community, but this variation goes against the well-being of the community, with the addition of increased alcohol consumption and loud music, general disorder, and the increased likelihood of disruption to the residents. And her representation is attached at Appendix 10. Now, in respect to the determination of this application, the panel must determine the application in accordance with the Licensing Act of 2003, the Mid-Sussex District Council licensing policy, and the Home Office guidance which is issued under Section 182 of the Licensing Act 2003, whilst having due regard to the applicant's submissions, relevant representations, and the hearing procedure under which the panel operates. Within the report, I've set out details of Section 34 and 35 of the Licensing Act, which relate to variation of licences. And if the panel have any particular questions with regard to those, I would obviously invite them to draw those to the attention of Mr. Mountney, who's present. Relevant representations. Now, the Licence Act of 2003 requires representations to address one or all of the 4 licensing objectives, which are the prevention of crime and disorder, the promotion of public safety, the prevention of a public nuisance, and the prevention of harm to children and young persons. And a representation is regarded as a relevant representation if it is about the likely effect of the grant of the licence on the promotion of the licensing objectives. The objector must establish that such a consequence is a likely effect of the grant, i.e. more probable than not. Within the report is detailed some of the guidance issued under Section 182 of the Licensing Act, which is pertinent to this application. At 9.3, where a representation concerning the licensing objectives is made by a responsible authority about a proposed operating schedule and is relevant, the licensing authority's discretion will be engaged. It will also be engaged if another person makes a relevant representation to the licensing authority which are not frivolous or vexatious. Relevant representations can be made in opposition to or in support of an application and can be made by any individual, body or business that has grounds to do so. The guidance addresses when a representation is regarded as relevant. A representation is relevant if it relates to the likely effect of the grant of the licence on the promotion of at least one of the licensing objectives. It gives an example of representation which wouldn't be relevant and one which would. But it goes on to say, in other words, representations should relate to the impact of licensable activities carried on from the premises on the objectives. And for representations in relation to variations to be relevant, they should be confined to the subject matter of the variation. There is no requirement for a responsible authority or other person to produce a recorded history of problems at the premises to support their representations. And just to clarify, the current premises licence isn't under review. So the panel is just to concern themselves in respect of the application rather than the actual premises licence as it stands at the moment. And it's the content of the application to vary the licence. It is for the licensing authority, and in this case yourselves, to determine whether a representation, other than a representation from a responsible authority, is frivolous or vexatious on the basis of what might normally be considered to be vexatious or frivolous. So a representation may be considered to be vexatious if it appears to be intended to cause aggravation or annoyance, whether to a competitor or other person, without reasonable cause or justification. And vexatious circumstances may arise because of disputes between rival businesses or between businesses and neighbours. Licensing authorities can consider the main effect of the representation and whether any inconvenience or expense caused by it could reasonably be considered to be proportionate. And the guidance goes on to state that it is recommended that in borderline cases, the benefit of the doubt about any aspect of a representation should be given to the person making that representation. And at the subsequent hearing, this would then provide an opportunity for the person or body making the representation to amplify or clarify it. Each responsible authority will be an expert in their respective field. And in some cases, it's likely that a particular responsible authority will be the licensing authority's main source of advice regarding a particular licensing objective. And obviously, in this case, the Environmental Protection Team are a particular responsible authority, which are your main source of advice in respect of prevention of a public nuisance. Licensing authorities must therefore consider all relevant representations from responsible authorities carefully, even where the reason for a particular responsible authority's interest or expertise in the promotion of a particular objective may not be immediately relevant. However, it remains incumbent on all responsible authorities to ensure that their representations can withstand the scrutiny to which they'll be subject of at a hearing. As a matter of practice, the panel should seek to focus the hearing on the steps considered appropriate to promote the particular licensing objective or objectives that have given rise to the specific representation and avoid straying into undisputed areas. A responsible authority or other person may choose to rely on their written representation. They may not add further representations to those disclosed to the applicant prior to the hearing, but they may expand on their existing representation and should be allowed sufficient time to do so within reasonable and practical limits. In determining the application, with a view to promoting the objectives, the overall interests of the local community, the licensing authority must give appropriate weight to the steps that are appropriate to promote the licensing objectives and the representations, including supporting information presented by all the parties, the guidance issued under section 182 and the statement of licensing policy. I've set out the various parts of the Mid-Sussex Statement of Licensing Policy, which the panel may well feel are relevant later in the report. And in respect of the appendices, Appendix 1 gives the application form as received by the licensing department. Appendix 2 details the current premises licence and the plan. If we go to Appendix 3, which is on page 47, the panel will see that I've got two area maps on there, one which is a satellite type view and one which is a more map type view. The location of the social club is marked on the both plans as Handcross Parish Hall. Parish Hall is located behind the social club. It gives some context to the panel as to the position of the premises and the residential premises which are around it. The next are a series of photographs which I've taken. The first two are of the entrance to the social club from the high street. And on the second picture, which is taken from the right-hand side of the entrance, the panel will see the social club to the rear of the picture in the centre. The next pictures are closer pictures of the social club. The first one being of the building, second one being of the a view from the metal fire escape or staircase to the rear of premises, then the entrance doors to the premises, and then a view down the right-hand side of the club towards the parish offices, and then from that area back up towards the high street. And as detailed earlier in my report, the Appendix 5 through to 10 are detailed the representations as received from the responsible authority and interested parties. That's the report before members this morning, and obviously I'm available if there are any questions in respect to the report I can assist members with.
And could I invite the licence holder to direct any questions to Mr. Bryant, if you have any? You have none, thank you. Could I invite Nicholas, if you have any questions for Mr. Bryant? You have none. Any questions from none whatsoever? We will move on. Thank you. Right, at this point, I would like to introduce again Trevor Stenning, and I would like you to make your representation to all of us, if I may.
Yes, the application is for us to have an extended licence up at Hancross Club. The reason being is that at 11 o'clock at night, quite a few of our regulars are still in the club. So we think it's only right that we try and extend the hours. We are not intending in 1 minute to stay open after 12 o'clock. But the reason we've asked for the extended even longer is so that if people are objecting to us being open later, we have got the situation in hand that we will be closing at 12 o'clock and not staying open till 1 o'clock. So we have asked for it to be extended to 1 o'clock for our own protection. So if we're open like at the moment with a new licence, and 11:30 we got, with the new licence we can cover ourselves in respect. If we stay open too late, people will start complaining. We don't want that. We're just a local club, which we want to be fair with everybody, and the reason the extra licence is so that we don't get complaints from the licensing officer or anybody else.
Thank you. Anything else? Nothing else you wish to say? Not really.
Yeah, well, I've got a...
You can push on.
we have, I know, who was it, Rhodes, Gal Balster, we're not open every night. We actually have 3 darts teams on a Monday and a Wednesday. We have quiz night on a Tuesday. We're open every single night from 7 to 11. That's how quiet it is. She doesn't actually know we're open. We've had recently on several occasions where our darts, these people come from all around Burgess Hill, Hayward Heath area, they come to play darts and have a tournament. Now, on several occasions lately, it's overrun, and the last one, 6 weeks ago, we had to scrap the whole game. We had to forfeit the match because we can't go on later than 11:30. We don't want the licence every night. We just want it in case things overrun, like our darts tournament. We used to be in the pool league. It's just there. It's better to have it and not need it than need it and not have it. All we want to do is have the ability. We do charity nights, a horse race night for the children's charity. That went on one night, nearly 12 o'clock by the time the man cleaned up. But we weren't serving drinks, he was just clearing the premises. But we need that just to take into account. Things do overrun. We don't want to be, we're voluntary. We work there voluntary. We don't get paid. We don't want to be there till 1 o'clock in the morning, but we don't want to break laws. We don't want the licensing officer, and we don't want people keep phoning up complaining. Although people have said they've phoned, they've got no proof. Even the police have said there's no evidence of people phoning up complaining. So all we want to do is cover ourselves. We would be closing at 11 o'clock, same as the Red Lion did, same as the Fountain did. We close at 11 as normal, but if things overrun, we have it there in case we need it. That's all we want. But not one person out of these 5 complaints has come and spoken to us, asked us our position. Nobody, not one. And now we're here.
Oh, thank you. I'm going to ask people if they'd like to ask you any questions.
Sure, okay.
Do you have any questions, Mr. Bryant?
No, Chair.
Thank you. Do you have any? No, Mr. Bennett. Would you have any questions? Right.
How many events do you anticipate having?
Yearly, monthly?
Annually?
Annually. We were looking at probably 5 to 6 karaoke's per night. We're trying to get that running again. We don't have it at the moment. We have 2 race nights per year. We have other events. I mean, people you know used to work at the club. People hire the place. If we do, I normally apply for a late licence for birthday parties, weddings. But if we have this licence, I won't need to. I can't predict if people are going to hire the hall. But roughly, annually, 2 a month, hopefully.
So more than 21?
Maybe. I mean, I can't predict. This is a guess.
You know about the temporary event licensing?
Yes, because I used to have to apply for it.
Okay. Also, one more question. Have you read the Mid-Sussex District Alcohol Licensing Policy?
Which part?
The policy,
What
the whole
relevant?
policy.
What relevant?
Yes or no? Have you read it?
I had many years ago, but I couldn't tell you a single
Thank you.
word of it.
Thank you.
Panel, do you have any questions?
I'll have a quick question.
Certainly.
How easy is it to get the temporary licence applications if you've got a special event on?
Normally, week to 2 weeks, £22 per application. But that's if you know the event's coming up.
Thank you.
Sorry, I just pushed the thing, but it didn't work. Just getting back to what Marianne was saying about our late nights and how many events that we had. I think our last time we actually applied for an application for a late licence was probably 3 years ago.
Minimum, yeah.
3 years ago. We don't want late things. So as for the 21 or whatever we can have per year, it's irrelevant because we usually have 1 or 2 maybe after for whatever reason. But we do not propose to have late licences every week and every month. We're not there for that. We're there to have a drink. If somebody wants to have a party, obviously it can't be 18s or 21s, then if we want the late licence, we apply for it. But as you can, we haven't applied for 3 years, so we've had no late licences, so we're not going on all night drinking. So, you know, the relevance of that is negligible.
Okay. I have just one question. When your smokers go outside, whereabouts on our photos do they congregate?
Where you see the front doors, the black...
Yes.
Just outside there, which we've had going on for the last 40 odd years. People just go outside the door and smoke. That's it. I mean...
We don't mind moving it. We can move it round to the side. There's not a problem. It's only the ashtrays that are on the wall. We can make a smoking. This is what I'm saying. Nobody's come and spoke to us. If they said, would you be prepared to move the smoking area? Not a problem. We'd move it. But nobody's asked us or told us what they want. So we just, like I say, this is why we're here, because nobody will communicate with us.
The only thing was I wondered if you'd ever given any consideration to, say, a covered area.
Yeah, that's what I mean. That's why I can move it round the side. It's not a problem. I'll do it. I'll put the cover up, the awning, whatever you
If you
need.
look in the picture, for around the side, there, where the patio area, the side bit there, that is our patio area, just
Yeah.
around the side there. We're quite happy to have people go round there to smoke rather than outside the front door. But because we've been going on for years and years and years, there's never been a problem, never been a complaint, so now this is all obviously revolving around to the situation today. So it's not a problem to be moved.
Thank you, thank you.
Can I ask another question, please?
You certainly may.
You say you want the hours extended purely as a buffer zone, but you would like to just keep the hours for the public as normal. What guarantees could you give that you wouldn't have late night drinking on a regular basis if you had extended hours?
Well, basically, all we can really do is cite what the Fountain had and the Red Lion have. They have 1 o'clock licences. They close when people go home. People don't, I mean, this is a small village with, I think, roughly 1,200 people in it. It's not as though it's a big city where we're going to be inundated with people. It's not. And people, I don't think, can afford to be drinking every single night till 1, 2, 3 in the morning. That's not going to happen. But all we want it there is, like I said to you before, is just as a fail-safe, if the things do overrun in life. So, I mean, he's nearly 70, I'm nearly 60. We're not going to be we're not party animals. We're not going to be nightclubbing and partying. We just want to provide the service for our customers.
Yeah, thank you. The reason I ask is for the neighbours.
Sure.
If you can give some sort of guarantee that there may be a darts event that overruns, which is fine, but during the week you close at 11.
Yeah. But like I say, I will talk to any of my neighbours, anyone that comes. I've been doing this since 1995, voluntary. I want to keep it open. I could have walked away at any time like other people have. It's not a problem. I can just go somewhere else. It doesn't matter. I don't drink, so it doesn't bother me. But I want to keep it open. We do charity events. We got a Macmillan coffee morning coming up. We're just trying to help the community whenever need. We're trying to get a child's club in the evenings with some of the parents that are helping, just so the kids have got in the village have got somewhere to go, because there is nothing in our village. Everything's closing down.
Thank you. Yeah, I do know Handcross. I used to play football there a lot.
So our reason is we are proposing, me and Ian, because we run it, our main objective is to have the late licence so that we cover ourselves. We will be closed at 12 o'clock every single night if we get the licence. I'm not going to start there later, he's not going to start there later. So I can quite understand why people are unhappy about it. But we are not going to be up there till 1 o'clock, raving it up and doing everything. It's not our idea. Our idea is to have a nice club, which it is. Regulars come up for a drink and go home. And that's all there is to it. I'd say 12 o'clock will be everybody, 12 o'clock, glass drinks, out by 12:30. That's our objective.
I noticed that, one of the complainants says about complaining to a local council. Now, it may not be that we've heard it through this council, but I wonder, presumably there is a parish council in Handcross.
Yes, and they
I wonder if there
voted,
have been representations from Handcross Parish Council about any complaints about your
No,
premises.
they've had a vote and passed our late licence. They've already done it.
But they've not in the past received any complaints about your premises?
Not as far as we know.
Okay, thank you.
Can I ask you to
Surely,
turn the
yeah.
microphone off, actually?
Sorry?
Could you turn the microphone off? Thank you. Right, thank you. Are there no more questions anywhere? No, lovely, right. Could I invite Nicholas, the Environmental Health Officer, to make your representation, please?
Am I audible? Can you all hear me okay? Yeah. Good morning. I'm Nick Bennett. I'm an Environmental Health Officer. I work for the Council's Environmental Protection Team. We deal with noise and nuisance as a key part of our work. You will have seen, I hope, my representation, which Mr. Bryant kindly summarised, and I just want to expand on it a little bit and explain the reasoning behind it. It's the Environmental Protection Team's opinion that this application doesn't adequately address the objective of the prevention of public nuisance by way of noise, and that If the application is granted as applied for, a public nuisance as defined by the Licensing Act would be caused to residents in the vicinity of Handcross Social Club. Guidance issued by the government and in the Mid-Sussex District Council licensing policy suggests that operating schedules should be precise and clear about the measures proposed to promote the licensing objectives, in this case, the prevention of public nuisance. Mid-Sussex's licensing policy also contains specific guidance on measures that can be taken to avoid public nuisance, and it would appear from the application that the applicant hasn't followed such guidance. As stated in my representation, we have no objection to the principle of varying the hours, but we do have serious concerns regarding the hours actually applied for. As you know, the club's in a village setting. It's set back off the high street in a cul-de-sac which is predominantly residential, with neighbouring properties located on all sides, 3 of them relatively close. It's about 150 metres or so from the A23 trunk route. Daytime traffic noise is audible, but as you would expect, at night time, background noise levels drop quite significantly. I'm not aware of the club having had any particular or special noise insulation adaptations, and none are proposed within the application. There's therefore the potential for noise breakout from the premises after 11 p.m, which could cause serious problems to nearby residential premises, as well as noise from patrons outside and those leaving at the end of the night. The types of disturbance are likely to be music, loud talking, laughter, singing, etc. The later at night the noise is, the more intrusive it is, and it's increasingly likely to affect sleep and cause anxiety, annoyance, and stress. As a council, we do want to support local businesses, but we're also obliged to promote the licensing objectives. So we try and find a balance that ideally satisfies all parties. And as you can imagine, this is quite a hard test to meet sometimes. So with regard to the specific changes that the applicants have put in, change to allow live music till midnight. We object strongly to this change. Live music typically tends to be louder than recorded music, and by definition, the volume is much harder to control. Given the proximity of residential properties, extension of the live music hours is not appropriate on any day, in our view, as it would be likely to cause a public nuisance. The sale of alcohol till midnight, Monday to Saturday, and midnight on Sunday, we do object to these hours. Customers will be using the outside area and also leaving the premises in a state of refreshment. From experience, we know that signage, whilst it can help, is no guarantee of compliance. Customer noise would be likely to cause a public nuisance, and that same reasoning really goes for the opening hours till 1 o'clock Monday to Saturday and midnight Sunday, which has been applied for. So we object to those hours too. The change to allow recorded music till midnight, we don't object to this change in principle, but it would need to match the opening hours, so that's where the issue is. I think it's fair to say that those who live near to licensed premises must accept that there will sometimes be an element of noise and disturbance. It goes with the territory. Nonetheless, these types of premises should not be given carte blanche to do as they wish, and the licensing objectives make it quite clear that there are limits, and there's clearly a responsibility to have due regard to residential neighbours. So, having looked at all of these factors together, on balance, our view is that the application in its current form is not appropriate or acceptable and doesn't meet all of the licensing objectives. Thank you.
Thank you. John, do you have any questions? No, I have no questions. Thank you. Do you have any questions for? Could you use? That's it. Lovely. It's all right. It's on.
It was on.
Yeah.
You said about noise reduction. We've actually stated in our application, all doors and windows will be shut after 11 o'clock, just to cut down on noise. I mean, what other measures are possible?
Well, typically for licensed premises that have music, live music after 11 p.m, we normally expect things like to avoid breakout of music from the premises, a double door system. Often they will have additional ventilation so that all the doors and windows can be kept shut, even in the summer when it's hot, so air conditioning, that sort of thing.
Have that.
And depending on the types of glazing or wall structure, there could be also additional insulation measures. So those are the sorts of measures you would normally
That's fine,
expect
yeah.
from
We have a double
music
door
venue.
situation, we have double glazing, we have an extractor fan to take any from our smoking days when it was allowed. I can't see what else we can actually do. But the license, the music thing, we can actually stop that for midweek. It's not there, it's just, we have the radio on. That's the music we have on during the week, Monday to Friday. So we're not going to have bands during the rest of the week. So we have the music license now, we pay for the licensing rights. Do you think having the radio on, that we normally have on, would be intrusive in every way, having it on for me for an extra hour and a half a night? I mean, our neighbours don't even hear this.
That's not really the issue. So, as I was trying to make clear, it's the live music till
12:30.
12:30.
Yeah.
That's the main issue. And so, with regard to recorded music, and the radio would come under that, I imagine. I've said I've got no objection to that change, as long as it matches the opening hours.
So live music will only be a Friday or a Saturday, will not be midweek. There's no reason
I think one of the issues we've got here is that you've applied for more than you intend to have by the sound of it, and we have to deal with the application that you've applied for. So if you apply for live music till 5 a.m, but say, oh, we're not going to have it till 5 a.m, that puts us in a difficult position. Are you able to clarify, would it be okay to ask Mr. Bryant if he can just clarify how we should approach that type of issue?
Mr. Bryant.
In this sort of case, I would obviously invite the applicants now to be specific as to what they're actually applying for, because the panel can obviously consider the other representations and whether or not the applicants wish to amend their application to reflect the hours which they mentioned during their presentation. Because if the applicants are willing to amend their application to a terminal time of midnight, it may well be that a different view or an alternative view is taken of the application by the panel, the interested parties and by the responsible authority. But at the moment, we're not at that position unless the applicant can clarify if they wish to amend their application at the moment. It can be amended at any time during this process.
Thank you, Mr. Bryant.
Yeah, we're quite happy to amend the live music, not later than John said, till midnight, from Sunday to Thursday. It's not a problem. We only really want it for Friday and Saturday.
Perhaps just for total clarification, for the panel and for the interested parties, it may be best if we go through each aspect of the application to confirm what hours are actually under consideration. So I'm just going back to the relevant part of the report. So it's at paragraph 10 on the report, which is at page 13. So we have currently, the application is to amend the timings for live music, Tuesday to Thursday, 11 a.m. till midnight. What would be the amended hours for that?
Live music, we can amend it to 12 o'clock if that's.
Well,
we have no problem. See, we've applied for a blanket, if you like, just to cover us in all ways, but we don't intend to have live music midweek.
Okay, if I could clarify for the applicants, what you've applied for is what you can actually have. So if you don't intend to have it till midnight, then I would suggest that you look to amend the application to the hours that you actually want, rather than hours you may. Of course. I don't know whether it might help the panel if the panel feels that an adjournment for perhaps 5 minutes would assist the applicants in going through these points to of clarification.
I think that's a wonderful idea. Are you happy with that? Yeah, okay. So we'll reconvene at 11 o'clock, yes?
Is this on the notice?
Mr Bryant, can I come to you to see what's been arranged?
Certainly, Chair. So the applicants have discussed possible amendments to their application, and what they have stated is that in respect of live music, Tuesday through to Thursday, they wish the hours for live music to stay as is on their current licence. For Friday and Saturday, they would asked or are applying for live music to remain as per the application. Recorded music hours to remain as per the application. Hours for the performance of dance, Friday and Saturday, to remain as per the application. Otherwise, to be as the current licence. Times for alcohol to remain as the application, and opening times to remain as per the application.
Where we were. Do the interested parties have any questions for our environmental health? No. Do the panel members have any questions for the environmental health? No. No. Thank you. No questions. So I'll move on. Could I?
Chair, you
Yes.
might wish to ask Mr Bennett whether or not he
Yes.
has any further comment in relation to the changes.
Do you have any further comment? Yeah. Wonderful. Sorry.
Thank you, Chair. So specifically on live music to start with, I initially objected to any extension of live music, and I gave my reasons. And my position on that hasn't changed. The applicants did ask about what measures typically could be put in place, or what further measures could be. I've found my copy of the guidance on controlling noise from premises such as pubs, clubs, village halls and other community buildings and outdoor event venues, which is available from the council. It's Mid-Sussex guidance. Have you seen that document? It's quite a detailed document and it gives a lot of measures. I've highlighted some of the more relevant ones. I think the point is that acoustics is complicated, and without knowing the acoustic properties of the building concerned, and without knowing exactly what measures would be required, and without an acoustic report, I feel that protection to the residents wouldn't be adequate without all of that information. So my objection to live music changing at all would remain. So I think the best way forward, in my view, would be either for the applicants to accept that live music doesn't go on beyond 11, or to perhaps make a new application providing the information required, like an acoustic report, so that we can then fairly assess whether the amended hours are reasonable or not. Does that make sense?
Thank you, yes.
Thank you.
Is there anything you would like to? No? Okay. Like to invite the interested parties to make your representation, please.
Good morning, Chair and members of the committee. I'm a resident who backs onto the club. You will all have read my representation and subsequent comments about the representation from Sussex Police at pages 65 to 68 of the report. Nothing I've heard so far this morning has changed any of my views expressed there. I do not intend to go over that again, but wish to expand on some points I made in representation due to information that has since come to light, which I will later expand on. Mr Stenning and Mr Rispin say the club wants extra hours to accommodate occasional events, not every day, as Mr Stenning has applied for. It is strange then that they have initially chosen to apply for an extra 365 days of additional hours for the sale of alcohol and entertainment. They've told you that they are aware of the temporary event notice procedures, which obviously they can get for 21 times per year. You will also note regarding your council's alcohol licensing policy, Mr Rispin said that he has read it, but despite this, they haven't complied with Section 9 regarding the steps taken to promote the licensing objectives. I will repeat my assertion that sorry, I didn't realise, I thought Mr Stenning was a licence holder. He has failed to follow your licensing policy guidance for applicants when addressing how he intends to promote the licensing objectives in support of his application for longer licensing hours. You will note, which Mr Bryant has said, that in 2009, the premises had a club certificate that was withdrawn by the licensing authority. The notice was served on Mr Stenning after the committee at the club had folded and he was the last man standing. He failed to inform the council about this, leaving them no option but to withdraw the certificate for the club, and a premises licence was then granted. More recently, in 2020, Mr Stenning was served a prohibition notice for breaking the COVID rules by opening his premises. He laughingly told the licensing officer that he was giving beer away for nothing. This wasn't allowed either. Further reports from local residents that the premises continued to trade followed, although they were never substantiated. The seriousness of this notice should not be underestimated. Other licensed premises in the UK had their licences revoked after receiving prohibition notices. Taken together and including the complete lack of anything meaningful in the application, these instances just show that Mr Stenning and others who run this establishment place scant regard to advice and, more importantly, to the licensing regulations. I note that Sussex Police has suggested a number of conditions for this licence that Mr Stenning has agreed to. It's disappointing to note that they do not query the additional hours and have managed to produce these conditions using the same lack of information in the application that I have taken issue with. I am pleased that Mr Bennett has submitted a representation on behalf of environmental health, and he has suggested the amendment to 2 days a week for extra hours with no live music at all after 11 o'clock. I am not in a position to agree with this, as I simply do not think those who run the premises will adhere to the conditions imposed. Their track record does not suggest they will comply. Chair and members of the committee, I understand that your options include granting the application as a whole, in part, or refusing outright. Were you minded to grant in part, I would ask you to impose another condition whereby the club must supply a noise management plan every year that must be agreed with the Environmental Health Department before any licensable activities can take place beyond 2300 hours. It should not include It should include music noise levels at specified residential locations. It should also include a telephone number for the premises where we can contact them in case of complaint at the time. In addition, I would ask you to restrict the number of times the licence can be extended as follows. A maximum of 2 events per month on a Friday or Saturday only, not on consecutive nights, terminal hour of midnight, sale of alcohol and recorded music only. All events must be pre-booked or pre-arranged before the night in question, and the documented record must be kept of all the times this facility is used. And this document must be produced to a member of the responsible authority on demand. Thank you very much for allowing me the time.
Thank you very much. Mr Bryant, do you have any questions?
No, Chair.
Thank you. Nick, do you have any questions?
No questions.
Thank you. Licence. Do you have any questions at all?
No, actually, obviously the COVID thing, what she's saying that obviously we broke the law on, it was a misunderstanding, and I quite agree. It happened, and the situation quite quickly was there was 2 people in the club. one was sitting at the bar, the other was sitting down the other end, and we were giving away free drinks to them people, so if that's classed as...
Their husband and wife and work.
Yeah, yeah. And they both worked in the club anyway, so yeah, we agree, I agree. I broke the law, but it wasn't intentional, it was something that, you know.
The
why-
two people
yeah.
were husband and wife.
Yeah,
that were in the
Thank,
club.
I don't think we need to continue
No,
with that.
sorry.
Anyway, that's fine, thank you, but nothing, no questions as
No,
such?
no, not so
No,
far.
okay, thank you.
Just very quickly, Chair, a number of conditions were read out there at the end of those representations. Did you have a chance to note those down? Did you need to hear them again?
I did get the noise management plan that was mooted,
Was
yes?
that it?
Yeah, no, in addition, telephone number for the premises. For a complaint at the time, either a mobile or landline or a person responsible. Music noise levels at specified residential locations. A maximum of 2 events per month. On a Friday and Saturday only. Not on consecutive nights. Closing at midnight. Sale of alcohol and recorded music only. And all events must be pre-booked or pre-arranged before the night and documented in a record and available to be produced to a member of responsible authority on demand.
I think I've got all of that, thank you. Do your events a month, does that include darts as well, or darts outside of that?
No, I'm thinking more of loud
Live
music, partying.
yes. Okay, thank you. Any other questions, panel? No? No? Okay, thank you. Let me go back to where I was. So, Mr. Stenning, would you like to sum up for us, or have you done that, do you feel?
Sorry?
Would you like to sum up for us, or have you done that as such?
What Marianne said?
No, to sum up to all of us why you are asking for this application to be granted.
Well, it's done itself. Yes, we are asking for this application so that we can do some things, rather than where we're closing at 11 o'clock. So if we do decide to do something, we can stay open a bit longer. That's all we're asking for. We're not asking to have music every night. I don't want it, he doesn't want it. We haven't had a disc out there for the last 3 years or whatever. We haven't had a late application thing for the last 3-4 years. So, you know, it's just something to us to be able to do if we want to. Words are very, very easy to say, but I can tell you we will not be open late at night for any other reason but to have a drink, and then they will be going home. So that's all there is to it. I'm sorry. Yeah.
Thank you, thank you.
Okay.
So you're going to,
That's it, Chair.
that says it.
So move on in the
Yeah.
agenda then, sorry. Thank you, Chair, this is passed to me. So the situation now is that the members of the panel and myself will retire to another room to assist the decision-making process. They'll discuss all the relevant representations and the comments and hopefully come to a decision today. If they cannot decide today, they will in any event come to a decision and communicate that to the various parties within 5 working days. They may come back with a decision but not reasons, but either way we'll make that clear in due course. Any correspondence that you receive in relation to today will also detail the position in relation to appeals. That will be within 21 days of receiving that appeal, that decision, and that will be at the Brighton Magistrates Court. But again, refer to the paperwork you receive should that be necessary. Before we retire, does anyone have any questions?
Any questions?
In which case, no, thank you.
No, then. Well, after much deliberation, we are happy with the change of name. Given that the location is in a quite residential area, we feel that there has been no exceptional circumstances shown for reasons to change the timings for live music, recorded music, or performance of dance. Alcohol sales also to remain the same as the current licence, but we are happy for the opening hours to allow them to be longer, so Monday to Saturday, 11 till 11:30, and Sunday, 12 o'clock till 11 o'clock. The conditions agreed between the police and the premises licensing holder at Appendix 4 should be added. Detailed reasons will follow in writing, and those changes will begin after the appeal window expires, which is 21 days. Okay? I don't know that there's anything else I need to say. I think that covers it, obviously.
Are there any questions?
Yeah,
Thank you for coming.
thank you.